Okay, we'll talk about arrest. Okay, the relevant statutes that provide for arrest, you must be very clear about your Article 5 of your federal constitution. That is the most important one. Okay, that is um the most I mean the most often used one. You should not miss this Article 5 whenever you answer the question in CPC in regards to this arrest method. Okay. Other than that, you should be familiarized with Section 15 to 33 of your CPC. Okay. Article 5 provides for liberty of the person. Okay. That means to say no person shall be deprived of his life or personal liberty. Okay, safe in accordance with law. It means everybody is free to do something. You cannot hunt a person. You cannot lock up a person in the custody without justified reason. Okay. Okay, so you also must be able to know at least, I'm saying the bare minimum, you must know the section index. Okay. For example, section 15 provides for the mode of arrest. Okay. For example, section 23 provide when a police or penghulu may arrest without warrant. Okay. Section 24, in the condition where a person refuse to cooperate. Okay, they don't want to give anything lah. The name, IC don't want to give, the address also don't want to give. Okay, so what can police do? Okay, please be familiarized with at least the headings. So during the examination time, whenever you see some unusual or exceptional question comes out, probably your previous ideas about how this index works, I mean, at least you know the title of the section, could lead you to find the answer there. Okay, please, very important. So from today onwards, put your textbook aside. I will seriously urge you to do so. Put your textbook aside, start reading this CPC. Okay, very important. Okay, so if you look at section 2 of your CPC, it does not provide a too comprehensive definition for seizable offense and also non-seizable offense. But you have to know uh, in a rather detailed manners, because I think this is quite a popular question. Okay, seizable offense in Malay means kesalahan hendaklah ditangkap. Okay, kesalahan hendaklah ditangkap. That means the police has got a right to arrest person without warrant, That means without the permission from the court, straight away I can handcuff you. Okay? So usually, seizable offense is obviously more serious and it carries imprisonment, usually more than 3 years. Okay? And the police officer can initiate the order to investigate without without having the permission of PP, public prosecutor. Okay, that means to say the police itself can open the file, can investigate the case because it is so serious. Okay, so any police officer below, not below the rank of sergeant, that means sergeant and above lah. Okay, so we are looking at usually in police station who will investigate the seizable offense. Usually it will be sergeant or sergeant major or inspector. Okay, these three people are usually the IO lah, the investigating officer that will be in charge of that particular seizable offense file. Okay, one file, one IP, one IP, one IO. Okay, as simple as that. So non-seizable offense, usually police has no authority to arrest without court warrant. And obviously it is less serious in nature, and it is for offenses which is punishable with imprisonment of less than 3 years. Okay, and police officer cannot proceed with the investigation of the case without the permission from public prosecution. Okay, PP, I mean DPP AGC, they did not approve it in writing for them to go ahead, then they cannot investigate at all. Okay, and if you refer to your section 2 CPC further, I want you to read from your section 2 CPC. Okay, if let's say, for example, if the offenses is less than 3 years or is less than the one that is provided in your this is what we call as if you flip to your first schedule, okay, and then you look at your third column. Okay, I'm not sure whether you know how to read this first schedule of you see there's a tabular statement of offenses under the penal code. Okay, if you read the first column, it will be your penal code and also section. The second column, it will be your offense. And the third column is the one that determine whether it is a seizable or non-seizable offense. And I quote, whether the police may ordinarily arrest without warrant or not. This is provided here. If the answer is do, D-O, do, usually it is not it is a seizable offense. Okay, please bear in mind. Okay, know how to read this because most of the time you'll be needing to make reference to determine an offense, whether it is a seizable offense or non-seizable offense, before you can comment the arrest itself is lawful or not. Okay, let's say, for example, wait, let me just mute on. Okay. Okay. Why I cannot unmute? Just give me a minute. All right. Okay. We continue. Let's say, for example, can you all still hear me and follow me? Can see my slides, right?
Yes,
Can still see my slides, huh? Okay, good. Okay, we continue. Say, for example, this one is too important. If any written law provides that even the offense itself is not punishable more than 3 years, for example, but somehow or rather the law, the specific statute provides that it is a form of seizable offense, then it will be automatically becomes a seizable offense. Please bear in mind, it does not necessarily means that if Section 2 CPC is not fulfilled, for example, the punishment is only 2 years. But somehow, if the statute provides that it is a seizable offense, okay, then the offense itself will automatically becomes a seizable offense. Okay, we'll look at the question later on. And later on, you need to know a summon case and warrant case. Okay, this is quite simple. Summon case usually is the one that carries punishment of less than 6 months imprisonment and it costs fine only. Warrant case applies to all other punishment more than 6 months imprisonment. Okay. Okay. Why we need to know summon case or warrant case? Okay. The thing is very simple. Summon case you can settle with compound. Baya saman. You heard about that, right? No need to go to court one. No need to have formal charge to be read against you. You can just pay your fine at the JPJ counter, police traffic counter, to name a few. So this is saman case. But usually warrant case, that means to say the court can issue warrant of arrest if you are not cooperative. Okay? If you're not cooperative. Please bear in mind, and formal charge must be framed because the penalty, the punishment is more than 6 months. Okay? Huh. So please remember that, okay? And you have bailable, non-bailable, and unbailable offense. Okay. This bail thing, I mean, the issue of bail will only occur after the accused face charge in the court. Okay, remember the court process that I have talked to you just now? Okay, um, actually there are two lah, police bail and also court bail. Okay, when arrest had been affected, that means the person will go to the lockup, isn't it? So within 24 hours, the person will be brought to magistrate to have remand proceeding. Okay, at that particular time, Brahman actually will prevails over the bail. So regardless whether it's a bailable or non-bailable, not important. Okay, so bail will only comes to place after the remand proceeding. Okay, that means remand another 3 days, then no more remand. So after that being bail or not bail. So this is the issue of consideration. Okay, so we'll look at this in a detailed manner in the bail chapter. Okay, at this moment of time, you just know, at least in your mind, you know about section 2, section 387, section 388 CPC, are the governing proviso or the proviso that is related to bail. Okay, if you can do that, I'm very happy for my teaching today already. Okay. No need to know about the detail first. Okay, just know there are three types. Okay, so now we look at the types of arrest. We have two types of arrest basically. The first one is without warrant. That means usually it applies to those seizable offense. Kesalahan yang hendaklah ditangkap. Okay. And with warrant. Okay. So these are the proviso in your CPC that you should refer to. This is why I urge to you to read at least the title of your CPC very well. So with warrant, it is provided under your section 38 to 43. So this condition, arrest with warrant, is applicable to those who have squandered, not cooperative. Those by right, they should attend court on this particular date. For example, 25th of January, by right, they should come to court. But somehow or other, they went missing in action. So the court can issue warrant tangkap for the police to go and find them and catch them back. So this is usually the situation. I'm just giving you one example. And so why do we need to know the mode of arrest? Okay. To know the mode of arrest is important because sometimes certain statute, especially again, we come back to the popular one, Dangerous Drug Act. Any statement made after the arrest can be used against the arrested person. Take for example, I was being arrested for Section 39B DDA for drug trafficking. So after the arrest had been affected or had took place, okay, so whatever I said that is possibly incriminating me, take for example, I admit or confess to the policeman that, oh, I did drug trafficking, or this pack of amphetamine belongs to me. This statement after the arrest could be admitted in the court, to held it against me. Okay, so this is why it is important to know about arrest. Okay, for DDA. Okay, DDA very important. Okay, this is one of the example of your caution statement. Okay, you look at this what we call this quote here. Adalah kewajipan saya memberi amaran kepada kamu bahawa kamu tidak diwajibkan berkata apa jua atau menjawab apa-apa soalan, tetapi apa-apa jua kamu katakan, sama ada sebagai jawapan sesuatu soalan atau tidak, boleh diberikan sebagai keterangan. So this is caution statement. Okay, so you must remember this caution statement must be given immediately the arrest, just like what you have watched US movie, Hong Kong drama. Okay, whatever you have said, lah, you have the right to remain silent, but whatever you said could be held against you in the court, something like that. Okay, so very important for you to know whether arrest had took place or not. So how to know whether it is arrest or not? We have statutory arrest. That means the mode of the arrest had been provided and described in statute. This is in reference to your section 15 CPC. Okay, three modes being provided. Either it is actual touching. Okay, that means I touch you. Okay, I hold your hand. Okay, I even pull your hair, something like that. There's a touching took place. It is considered arrest already. Okay, bear in mind, the word here is or, or, atau, okay. So B, confining the person, the body of the person sought to be arrest. Even though I don't touch you, I keep a distance, but you are being surrounded by a group of narcotics team or police. How can you escape? Isn't it? You are being confined. You cannot go anywhere. You are being locked in the room. Okay, you cannot climb the stair. I mean, can't climb down from 10th floor condominium and be a Spider-Man to escape, isn't it? So this is an arrest, or there's a submission to custody by word or action. Okay, usually police will say, freeze lah. Okay, if not, I'll shoot you. Freeze, you are under arrest. This is submission to custody by word or action. Okay, or they will say you are under arrest. So there are three modes here. Okay, so what about common law arrest? Okay, you have to look at this together with section 15. Okay, common law arrest means the court themselves had interpreted the meaning of arrest, okay, using their judicial consideration and appreciation of the circumstances. Okay, so they had given us by the case of Shaban against Chong Fuk Kam, three important proposition. A, police states in terms that he's arresting. Saya tangkap kamu. Awak telah ditangkap. Okay, you are under arrest. Already said it. Okay. B, use force to restrain. Okay, you are already being pressed down to the floor. Okay, you are being asked to squat. Okay, by the police, and the police already control you. Okay, this is proposition B. And C, the police make it clear by words or conduct using a gun, pointing you from far. Okay, and said, stop running. You are under arrest. Freeze, something like that. Berhenti. Okay, jangan lari. Something like that. So to prevent person from going anywhere that he wanted to go. So this is under the common law principle of arrest. So actually, it is a wider scope than statutory arrest. Okay, do not attempt to compare with your section 15 CPC and further confuse yourself. It is entirely not necessary. Okay, just know What is arrest at this moment? And you have actual arrest and constructive arrest. The distinction between actual and constructive arrest was actually being declared now. Lah. I mean, at this moment of time, we do not say this is an actual or constructive arrest anymore. You can see the case of Kang Ho So, okay? Because it's very hard for you to put a boundary, okay? And this is very important. So first, you determine what is the offenses, okay? Seizable, non-seizable. And then you determine whether the arrest is either by Shaban, your common law, or your section 15 took place or not. And third, you must look at who is arresting the suspect. Okay, very important, eh? Okay, because the governing proviso for the arrest for different group of people is different. Okay, the popular one, I would say lah, the popular one will be your section 23. Okay, 23. Hmm. Okay, 24 also sometimes it got come out, but 23 you must be seriously know it by heart. Okay, the whole section. Don't just read from textbook. Again, I urge you, look at what CPC say. Okay, and sometimes you have your private person that can also assist the police to stop a crime. Okay, to arrest lawfully an individual that is suspected to commit an offense. Okay, so I would like to invite you to look at the most important section of your arrest here. That is your section 23, sub rule 1. Okay, so any police officer, it says that any police officer or penghulu may, without an order from a magistrate and without a warrant, arrest. Okay, A, any that means to say, arrest any person who has concern in any offense committed anywhere in Malaysia, which is seizable offense, okay, under any law enforced in that part of Malaysia in which it was committed or against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists of his having been so concerned. Okay, so this is your um the proviso for arrest, which is the most popular one. Okay, most popular one. Okay, it has got a few criteria that we are going to discuss in the question later. Okay, and B, the one, the keyword here is the housebreaking. Okay, and C, the provided under your section 44. Okay, so what is your 44? Let's have a look. Okay, the person that is absconding cannot attend the court one. Okay, usually the court will issue warrant to arrest them. Okay, um, the wanted, you know what is wanted? Bounty, bounty. The police sometimes will advertise who is being wanted, something like that. Okay, this is pursuant your section 44. And your D is possession of anything suspected to be stolen or fraudulently obtained property. This is bongkar lah. That means you kept something that is not belong to you, and people report it. It got stolen. For example, a handphone or a car parked inside a stolen car inside your house. So the police can actually catch you for bongkar lah. Okay, and escape from lawful custody. And this one, the rest not so important, but you just read a little bit. Okay, H is very interesting for those who is menganggo, those loitering around, walking around at the streets, middle of the night, okay, looks suspicious, and then cannot uh, give a satisfactory explanation to the police, but somehow or other the police find this guy is fishy, then they have the authority to arrest without a warrant. Okay, and it is lawful under the proviso of sub-rule H. And a habitual robber, housebreaker, and if you are so well known, like you know, you are some Robin Hood, Robin Hood in your district area, you also be aware lah. Police will invite you for a cup of coffee in Balai Police very often lah. If any theft reported, okay, they can arrest you if you are known to be a habitual thief or robber. Okay, so this is all about 23. Okay, so you must identify who can arrest police or penghulu and what is the offense pursuant to your section 23 subrule A 1 subrule A. Okay, 23 1A. Okay, so it is only seizable offenses. That's why it's very important to determine what type of offense first. M, you have a few criteria. Okay, this is all being read disjunctively because it carry the word here, or are, okay, or atau. That means one of the criteria here, reasonable complaint, so long they got information, they got complaint, okay, they think this is, wow, makes sense lah. This guy could be related to the murder of his wife lah. I mean, Chee lah, could be related because they have a sour relationship, or then they can arrest already without warrant. Okay, or the so-called information they gather has a reasonable suspicion that the person ought to be arrested for further investigation. They can arrest. Okay, reasonable suspicion means here I have doubt that you probably committed a crime, but now I don't have proof. Okay, so there's a distinction between reasonable suspicion, or the favorite term here is prima facie proof. Okay, it's different. Reasonable suspicion, you only need to reach a very little threshold. Okay, and credible information. Okay, this is all to be read by the word or atau disjunctively. Bear in mind, okay? Again, I urge you, spend more time on the statute. Do not go and argue and give a long description about what is Hashim Sao against Yahya Hashim and all that. Don't spend too much time. Tackle on the question, okay? And your section 24 CPC. Who can arrest? A person or a hulu. And it is applicable for non-seizable offense. Okay, bear in mind, non-seizable offense, it comes under your section 24 CPC. Okay, so if you have your sub rule 1, which is the popular one, the drunk individual under alcohol influence or under some drug intoxication, they cannot tell you, isn't it? Where they stay, what is their name, they lost their IC. So if the police officer thinks they are suspicious individual, they can arrest them. Okay. So this is under this proviso. Okay, section 24 subrule 1. Okay. And if you have read further, subsection 24 subrule 2, when any person is taken, okay, before a magistrate, the magistrate may either require him to execute a bond. That means to say you must jamin lah, ikat jamin, or to order him to detain in custody until he can be tried. So that's why I say usually this typical scenario here will be those person that under drugs or alcohol influence. Okay, popular question. And even having said so, if let's say the person is so-called a foreigner, they have the residential address is not within Malaysia, under Section 24 Sub-Rule 3, it is wider, you know. You can arrest this person, you know. For example, a person that is from Bangladesh, okay, committed a non-seizable offense, but somehow his passport show that he's not residing in Malaysia, isn't it? So the police can arrest them, okay, but not by a person that is below a rank of inspector. Okay, please bear in mind, because you must think that way lah. The arrest means the police need a person, not suka-suka hati, you know, the arrest because they need the person to come to the balai to give cooperation. They want to record Section 112 statement. They want to take urine sample. They want to take fingerprint or do kawat cam, the identification, okay, to determine whether you are the culprit or you are the offender of that crime or not. So the proviso make these police jobs easier, okay? And if the arrest is affected by penghulu, uh, the penghulu must take one further step to go to the nearest police station, and the police will tangkap semula, okay? Re-arrest must take place, then only is it lawful, okay? The penghulu cannot bring the person for remand. It must go through police. Okay, very important. And your section 27, arrest by private person. Okay, we cannot rely on authority at most time, because usually the crimes will be committed in private place. Nobody will be so dumb and also stupid enough to commit the crime in front of police, isn't it? Usually this is not the case lah. They'll find a place where there's nobody surround, then they'll snatch your beautiful Rolex, they'll snatch your purse or whatever, isn't it? So the private person has also been empowered under your criminal procedure code to effect the arrest, okay? To help the authority, to help the state to prevent crimes, okay, in this matter. Okay, otherwise nobody will help, isn't it? If let's say, for example, if I arrest you, then you sue me for trespass to person, for battery lah. Then I have to pay you some more, susah lah. Then who is going to do the job? So section 27 is the arrest by private person. And what should the private person do therein after? Okay, so you read this section 27 1. No, the whole section thoroughly, lah, please. Okay, so section 27 sub-rule 1 provides that any person or any private person may arrest any person who, in his view, commits a non-bailable, here comes the definition, isn't it? And seizable offense, or who has been proclaimed under section 44. That one, the wanted lah, the bounty list lah. I give you 10,000 if you catch this person. You can see it sometime in the website, you know, the IPD website. Okay, and shall, without unnecessary delay, hand over the person so arrested to the nearest police officer, or in the absence of the police officer, take the person to the nearest police station. So this is what the arrest person should do. Okay. And sub-rule 2, if there's a reason to believe that such person come under the proviso of section 23, a police officer shall re-arrest him. Okay, so that means to say, when the person is attended by a police officer or go to the police station, the police will ask lah, apa salah you buat? Oh, saya rompak lah. Rompak okay, you check your penal code. Oh, it is a seizable offense. So, tangkap semula. Okay, faham And section sub-rule 3, if the person is committing some sort of non-seizable offense. For example, he's just committing forgery of document lah, forgery and forge a signature. Okay, this is non-seizable offense. So, but he refused to give cooperation to the police officer. So it will come back again under section 24. That means to say he's not giving his ID to the police to facilitate the investigation to be done by the police, and the police can arrest him again under section 24, which we have discussed before. Okay. And sub-rule 4, if there is no reason to believe he had committed an offense, that means the person, for example, just throwing some rubbish or just talking some defamatory words to you. I said that you are so fat and you are not handsome at all. Okay, this does not amount to an offense, isn't it? But this is rather a civil action in regards to defamation. So it's not a offense. You cannot arrest me and bring me to the police station. Okay, so the person shall be released. Okay, under your sub rule 4. Okay, and sub rule 5. Any person who commits an offense on or with respect to the property. Okay, that one is quite important. If somebody suddenly appear in your house without any reason, okay, like he's going to injure you or injure your property, then you can arrest. Okay, somebody just trying to, trying to unlock your car or break into your house. Okay, these are under your sub rule 5 of your section 27. Okay, very important, please. Okay. Hmm. Okay. And sub-rule 6, if any person lawfully apprehended under subsection 5 assaults or forcibly resists the person by whom he is so apprehended, or any person acting in his aid, he shall be liable to 100 ringgit also. Okay, this is quite important. So that's why I think what you need to do now is to read your statute. Okay, because from what I realize is most of the textbook, they do not cover that much about, they do not repeat what is the content of the statute, but the statute is more important for you um to analyze the question well. Okay, the magistrate hardly arrest lah nowadays. Magistrate, usually they are quite busy with their works, they don't arrest in person, and we have police officer to instruct, and this becomes less popular in our exam question. So does the justice of peace, JP. Okay, and the warrants part is all governed by your section 40, 41, 42. Okay, and the police can also arrest person, not open the commission of the offense, to prevent a seizable offenses could happen. Okay, that means to say the police, if they know there's a plan for you to rob bank, they don't need to wait the moment you rob the bank, then they arrest you. But they can arrest you whenever you are planning inside the small house in preparation of the weapon, and also you draw the bank, the layout of the banks itself, then they can arrest you already. Okay, this is in preventing the crimes to take place. Okay, we comes to the more important part. Okay, the rights of arrest person, you must refer to your section 28A and section 28 of CPC. This is bare minimum. Section 28A and 28 of CPC. 28A dengan 28 CPC. Okay. So you must be informed what is the ground of arrest. Apakah sebab ditangkap? Okay. This is also pursuant to your Article 5, Sub-Rule 3 of Federal Constitution. Okay, if you want, you can refer to the case of Christie against Lichinsky. Okay, this is famous classical case. Just remember one enough. Okay, ground of arrest. Remember, eh? And secondly, you have rights to communicate or consult legal practitioner. Okay, that means to say you can talk to a lawyer. Okay, you are given the rights to call your lawyers. Okay, very important. This is under your section 28A, sub-rule 2, sub-rule B, CPC, and also article 5, sub-rule 3 of your federal constitution. Okay, and this right is um highly privileged for the arrestee. Okay, and of course this is not an absolute right, but subjected to the strict compliance by the police. Okay, you can see the case of We Apua against OCCI Kedah Police. Okay. Mm. If this right is being denied, you can probably sue the government by civil action. Okay, and you have rights to communicate with relative or friend to inform your whereabouts. Okay, you can call your wife, you can call your friend to inform him. Okay, I was being arrested and I'm going to Balai Police to Pahat. So the friends know where to find you. Okay, this is the sole purpose for the communication to be affected. It's not to call your accomplice, to call your other suspect. Cepat lari lah, police sudah tangkap saya. It's not like that. Please. Okay. Section 28A, sub-rule 2, sub-rule A, CPC. Okay, the purpose is only to inform which balai police that you are about to go. Okay, that's why I said you must remember by your heart lah. Section 28A. Okay, the communication should be allowed as soon as maybe. Okay, this is your section 28A sub rule 3 CPC. Okay, as soon as maybe doesn't mean that okay, you tak boleh telefon you kena masuk lock up dulu. Not like that. The moment that you are being informed, you know the section 15, Shaban, mode of arrest, the arrest had been deemed to take place already, then you can call already. You can call your lawyer or your friend already. Okay, that is what it means by as soon as maybe. Okay, and the said rights to communicate with outsiders are not absolute rights, subjected to the exception of your section 28A sub-rule 8. Okay, section 28A kurungan 8. Okay, please memorize that. Okay, so what does section 28A sub-rule 8 say? Okay, the requirement for communication does not apply where the police officer reasonably believe that compliance with the requirement will result in number one, an accomplice of the person arrested likely taking steps to avoid apprehension. Like the example that I have given. The purpose that you call your friend is to ask him to run away. Awak kena cabut lah sekarang. Like that, cannot. Okay, that's the first criteria. And second criteria, the concealment, fabrication, or destruction of evidence or intimidation of witness. Okay, you hide a knife in the cupboard where your parents are staying, okay, the house. You call your parents, ask them to throw the knife into the river so that the police can never find it again. Cannot also, okay? Or you call the witness because you involved with a fight with your wife. For example, you are charged under which section? Section 323 lah. Easy one. The causing hurt. Okay. punch your wife at the face. Okay, you call your wife and say, "Hey, berani kau, you call police tangkap saya." You intimidate, you try to temper the witness. Okay, you try to intimidate the witness. This one also cannot be allowed. Okay, and uh, just remember, okay, your section 28A sub-rule 8, okay? And the denial can only be authorized by DSP, the Deputy Superintendent of Police. Okay, this is also written by your section 28 sub-rule 28A sub-rule 9 CPC, okay? And the police officer, the IO, must record the grounds. Okay, what is the reason that you deny the communication? Okay, do you suspect that your intelligence will be sabotaged? Do you suspect that the reason of the so-called call or communication can disrupt the whole investigation? So you must state the grounds, okay? But once the reason stated inside your section 28 sub-rule A, okay, 28A sub-rule 8 had gone already. That means you already caught all the core accused. That means to say the accomplice of the drugs, the whole syndicate, you tangkap semua. Okay, there's nobody else to run. Then you must allow the accused to the arrestee to communicate with their friends or family or to talk to lawyer. Okay, this is also be provided under your section 28A sub rule 11 CPC. Okay, the so-called denial does not last forever. You must understand by your heart that the bar, the denial from communication is merely to assist the police to carry on their investigation expeditiously. Okay? And it is not meant forever. Okay? Mm. And the rights of the person, right to remain silent. Okay? A person that is being arrested does not necessarily answer any question that is asked by the police. The police will ask you lah, of course lah, to make their life easier. Where do you hide the body? Then it will be easier, isn't it? I would say I have thrown my wife's body in the Sungai Melaka, which part? Beside there, there's a KFC, something like that. It will make things easier. You have the right to remain silent. I don't know. Or you just mute yourself. You don't answer any question. Okay, this is allowed. Okay, this is pursuant to your section 112 sub rule 2 CPC when they want to do rakaman percakapan. Okay, the statement. Okay, so in accordance to one case law here, Omar Dao against PT, remain silence is as of legal rights conferred to the arrestee. Okay, you remain silent does not means that you admit to the facts that asked by the police. So there could not be any adverse inference to be drawn against you. Okay, under your Evidence Act, this is under your Section 14 sub-rule G. Okay, it's not sub-rule, sorry, illustration G. Okay, and the rights to be brought to magistrate within 24 hours. Okay, the police can only arrest you for 24 hours. After that 24 hours, the detention will be illegal if they did not produce you to magistrate to get remand. Okay, so remand proceeding is very important. I repeat myself, the police can only keep you inside the police station within 24 hours for all offenses. Okay, regardless this is a murder, drug trafficking that carries a death penalty, they can only keep you in the balai 24 hours. Within that 24 hours, they must bring you to magistrate, okay, to face the magistrate, Okay, and then they will present themselves, the IO, the investigating officer, usually sergeant or inspector, they'll present, okay, so and so have been arrested for suspecting murdering his wife. For example, me lah, I was suspected, so I demand for 7 days for the first remand. So the police will, the magistrate shall, at his or her discretion, grant the remand to the police in order for them to complete the investigation. Because 24 hours is just very little times, For you to find the body, for you to gather the evidence to charge a person, it will definitely take time. So at the same time, you do not want to alert the person, oh, I already catch you. What if Chi go back to his parents' house and destroy all the investigation? I mean, all the evidence, isn't it? The knife, the blood, clothes, all the whatever collateral or corroborative evidence have been destroyed. So there's a rule provided for remand, okay? Bear in mind, So section 28 sub rule 3 and also Article 5 sub rule 4 of Federal Constitution is the thing that you want to use here. Rights to be brought to magistrate within 24 hours. Okay. Uh, and then the remand proceeding will entail. Okay. It will be followed by remand proceeding. Remand proceeding we will discuss in our next chapter. At this moment of time, do not confuse yourself with section 117, section 119, or all that. No need first, okay? And the rights for bail, yes, police bail, you can get it from the what we call the police officer, section 29. Okay, if you refer to section 29, whoever that is ranked more than inspector, they can grant bail to a person. Okay, this is police bail, jamin mulut. Okay, remember that, jamin mulut. And then you have another thing called court bail. That is when the charge had been read to you, then you ikat jamin. Probably you have to get a surety, pejamin, and you have to give some wang jamin to the court. This is by the section 387, section 388 of your CPC. And other than that, you have rights for self-defense. If the police did not introduce you themselves, and then suddenly somebody impose some force on you, automatically you think somebody is trying to rob you, isn't it? Then you punch him on the face. Okay, this is called self-defense. Okay, and if the police did not follow the right procedure, then your resistance towards their arrest is lawful. Okay, and the rights to civil suits, yes, if the arrest is just simply a sabotage, is just absurd and injustice one for some political purpose, you can initiate a civil suits against Ketua Polis Negara, for example, and also, of course, government of Malaysia lah. Okay, and rights to habeas corpus. If the detention, for example, under SOSMA, all that is a very long one, 28 days. Okay, so actually you can have a separate uh, proceeding in high court, just to bring you to the face of justice to see the judge, the high court judge, and to see whether your detention is justifiable or not. So this is called rights to habeas corpus. Okay, and habeas corpus is another form of what we call how justice, the criminal justice is being served in Malaysia. Okay, and it is provided under your section 365 up to section 375, usually applicable for prolonged detention that is not justifiable. Okay. Mm. So the proviso, the how to do is all provided here lah. Okay. Should you have any question in relates to habeas corpus? I think none so far. I have not seen this question for years. So the right procedure that you should write, I mean, contain in your answer will be this uh, all this proviso. Okay. And one more thing you must bear in mind that even if the said arrest is unlawful, it does not actually reshape the subsequent trial. That means to say the initial part of the arrest itself is without any reason. They just catch by coincidence. But somehow or other, you are being charged to the court with a little bit of evidence, it will not reshape the proceeding itself, you know. It doesn't nullify the trial. Please remember that. Okay. And you can use the case of Saminathan against PP. Try to understand the principle of the law, then uh you memorize your case law, not the other way around. Otherwise, I think you will be lost. Okay. So we try to answer one question here. Okay, this is a 2023 question. On 10th of April 2023 at about 6:15 p.m., a team of police officers headed by ASP Abu, so you know the rank of the police officer now, raided the premises of BTS Publishing Sundaram Bahat in Brickfields based on the information received by the police. So during the raid, the police seized two books written by Boyi TS. So thereafter known as BTS. So upon perusing and checking the contents of the book, ASP Abu arrested BTS, who was in the premise. So BTS was informed, see it clearly, BTS was informed that the content of his book tend to bring hatred, contempt, or to excite this affection against the government and the administration of justice in Malaysia. So what has come into your mind? Hope the very unpopular sedition act among the politician, okay? Tahasutan, okay? And he was taken by ASP Abu to Balai Polis Dang Wangi, okay? Another popular place in Malaysia. And he was kept in remand that night. Okay. No statement was recorded from him. The following day, okay, so he was arrested at about 6:15 p.m. evening, and the following day, he was brought before a magistrate where he was ordered to be remanded in police custody for 1 day. So ASP, the IO, bring him to see magistrate. Magistrate grant 1 more day. So after having his statement recorded by police, BTS was released the day after. There was no other investigation carried out on BTS other than recording his statement. BTS was also not charged for any offense. Just like that, no further action. Okay. So examine whether the arrest of BTS was lawful or not. So this is your question. So in order to understand this question, you must dissect the question into several parts that I have listed down at your right. If you have examined this, you must look at this. What is the offense committed, possibly committed by BOETS, BTS? Okay. And who had made the arrest. Okay, that means is it done by private person, penghulu, or police? Okay, because later on you need to discuss the relevant section. You know, so does what is the type of arrest? Is it done with warrant or without warrant? So which section of CPC uh, must be used here? And what are the rights of the arrestee? That means to say, is BTS being entitled to all his right throughout the arrest? Okay. And within this first 24 hours, nothing was done because statement was not recorded and he was being remanded 1 day. So we have to chronologically answer this question. So my suggested answer to you is BTS is likely being arrested by SP Abu under Section 4 of Sedition Act 1948. If he is found guilty of this offense, BTS shall likely on conviction, okay, to be liable for a fine not exceeding 5,000 ringgit or to imprisonment for a term not exceeding 3 years or both. Okay, on the first surface itself, it looks like a non-seizable offense because Section 2 CPC usually based on your third column of first schedule, the penal codes there usually less than 3 years imprisonment. It is non-seizable offense. But you must also remember one point. Sections 2 CPC also provide that if any other written law said it is a seizable offense, then it becomes a seizable offense. So you look at section 11 of Sedition Act 1948. That's why CLP very hard to pass. This is because of this reason. You must have thorough understanding of the statute and also the specific criminal law. If you just hantam, you just hantam this what we call the whatever the you do know the what is the offense committed, my advice to you, you skip this question. If not, your submission might be wrong. Okay, because you do know which offense is committed by this BTS, then you do know whether the arrest is lawful or not. You cannot argue on the superficial knowledge that you have. Okay, cannot like that. So Section 11 Sedition Act 1948 provides that any police officer not below the rank of inspector may arrest without warrant. Okay, that is found to have committed Section 4 of Sedition Act, which is committed likely to be committed by BTS lah. So you see the arrest done by whom? ASP Abu. ASP is ranked above the inspector, right? Under the Police Act, okay? So it is a lawful until now, okay? And then subsequently, you go on to discuss Section 23, Subrule 1, Subrule A of your CPC. So under this, ASP Abu is authorized to arrest Bo ETS for committing a seditious offense in Brickfield, Malaysia, a seizable offense. Okay, because according to Sedition Act, Section 11, it is seizable. This action is subject. This action, that means this arrest, pursuant to your Section 23, Subrule 1, Subrule A, is subject to one of the following condition. A reasonable complaint has been made, or there is credible information, or there is reasonable suspicion. So you relate the law to the fact again. Okay, you cannot just comment everything and cite this Shaban, Tekai all this Yaya Hashim, all this case. It's not like that. So you have to further support your position here. So on the fact, the police made the arrest based on the information received. They did say, right? And subsequently, SB Abu did read the contents of the book, which possibly give rise to reasonable suspicion that BTS commit sedition. Okay, an offense under Section 4 lah. Okay, so you must at the end of the day say that Section 23 Subrule 1 Subrule A CPC is fulfilled based on the reasoning above. Okay, you get me? An open arrest, BTS was told the contents of the book tend to bring hatred, contempt, or to excite disaffection against the government and the administration of justice in Malaysia. Okay, so you are now further discuss what is the right of BTS. Despite he did not being told the exact proviso, which section of Sedition Act. No, he didn't even being told he committed offense under Sedition Act. So even though there's no precise description, but still the arrest is lawful because the ground of arrest pursuant to your section 28A, subrule 1 CPC, and Article 5, Subrule 3 of your federal constitution was clearly acknowledged by BTS. Okay, he was being told by SB why you being arrested already. So the grounds have been of the arrest had been told to her. Okay, and then you can use the case refer Christie against Lishinsky here. Okay, and subsequently, BTS was taken into Balai Police Dang Wangi and remanded for 1 day. Okay, so the rights to communicate or consult legal practitioner or friends or relative pursuant to Section 28A Subrule 2 CPC, Article 5 Subrule 3 Federal Constitution. Okay, the rights is silent. I mean, the facts itself is silent to the mistake. So you jump into two hypotheses. I will submit as such. The fact is not conclusive whether BTS opt not to do so or her rights was being denied. So you do not need to be too imaginative. You just need to tell that the rights of to communicate must be there. So if BTS opt not to do so, the police did not infringe the law. I mean to say the BTS, he himself did not uh, wanted to call any friend. He just want to leave it there. No intention to communicate with any friends. So the police arrest is still lawful. Okay. If BTS was denied with such rights, the authority must come from a police officer above the rank of the SP. So this is section 28A sub-rule 9 CPC subjected to the criteria under your section 28A sub-rule 8 CPC. Okay, so you briefly discuss this, okay, and you use the case of OER 4. And the next day, BTS was brought to magistrate within 24 hours. Okay, okay, because I lightly said so because 6:15 was the time of arrest, 6:15 p.m. So the following day, you remand usually morning, okay, based on our legal practice here. So it is within 24 hours. Article 5, sub-rule 4, and your section 28, sub-rule 3. And BTS was subjected to remand proceeding as provided under your section 117 CPC, where she was remanded for 1 day by magistrate in reliance to your section 117, sub-rule 2, sub-rule 8. Okay, arguably, now no statement was recorded from BTS on the day of arrest. However, I will submit in such a way, the fact was not clear whether investigation diary pursuant to section 119 CPC may contain other works done by police. It doesn't mean that the statement was not recorded, the police does not did other works. For example, interrogating other witness, collecting the publication intel, etc. Okay, then I will likely said that even the remand itself is lawful. Okay. Subsequently, because I chronologically frame my answer, this is how it works. So BTS was recorded with statement under section 112 CPC. She was released thereafter. The fact that no further investigation and BTS was not charged by the prosecution have no bearing to the legality and validity of the arrest. Arrest is merely the first step of criminal proceeding against a suspected person. So you cover your question thoroughly. So you conclude at the end of the day, say that after thorough examination, it is submitted that the arrest is lawful. Okay, so this is your full answer. Okay, and I have made some interesting search. If you are keen to read, you can read the slides later. So this is very mimic to our scenario given. Okay, all right. Wow,